The question for Attorney Hampson. Rule 30E3 of the Rules of Appellate Procedure states that the citation of unpublished decisions of the Court of Appeals is disfavored, but goes on to describe how a lawyer is to utilize such unpublished opinions if bound and determined to do so. For years, there has been debate among appellate lawyers like yourself and judges regarding the proper role of unpublished opinions in the development of a coherent and consistent body of law to govern North Carolina's business and personal relationships. What is your own view of the value and proper use of the court's unpublished opinions?
Good morning. I am Toby Hampson. I am running for Judge Calabria's seat, who I've known since she was elected to the bench in 2002. It'll be shown as seat number 2 on your ballot this year. Before I get to my remarks, I do want to make one correction to an apparent misstatement on the form. I was not, in fact, the clerk of U.S. District Court, U.S. Court of Appeals from 1977 to 1978, if for no other reason than I would have been 2 or 3 years old at the time, so that's an apparent mistake. Let me turn to the question first. Rule 30E is pretty clear about the use of unpublished opinions. They can be used for purposes of showing claim preclusion or issue preclusion. They can be used for demonstrating the law of the case from a prior appeal. They can also be used by practitioners in an instance where the practitioner believes that the unpublished opinion does in fact have precedential value to a material issue in the case. Now, from my standpoint, unpublished opinions are often really, really useful as an appellate practitioner for purposes of taking established legal principles and showing how they've been applied to a particular set of facts. So you can find in this large body of unpublished opinions a number of cases where you may find an analogous factual situation being applied to establish legal principles. And I think the benefit of that is it helps the courts, it helps practitioners provide some consistency of how we are applying these established legal principles to factual scenarios. So I find them very, very useful for that purpose. But I think it is really vital that we both as practitioners and the courts understand that there is a very large and growing body of unpublished case law. And in fact, we're seeing scenarios where you may even have lines of unpublished cases where you have unpublished opinions citing to an unpublished opinion for a principle. Of course, the danger there is then you have a published opinion that comes along later that overrules those unpublished opinions on the basis that they were just unpublished opinions without precedential value. We saw that in the zoning and municipal area where you had the Whitson case out of Camden County, which held that the failure to join a necessary party in an appeal to Superior Court was a jurisdictional defect. The Philadelphia case, a second unpublished opinion, said the same thing. Then you had the NYC Klepper case, which was a published opinion that came along, took the opposite position, and even chastised the lawyers for relying on those unpublished opinions because they were non-precedential binding authority. So I think it really is important to be cognizant of this growing body of unpublished case law that's out there. Now about me. I am Toby Hampson. North Carolina, I was not born in North Carolina, but North Carolina's home. I grew up mainly down in Moore County, attending schools like Sandhills Farm Life, Union Pines Elementary. I graduated from the School of Science and Math, went to American University in DC, and then came back home to Campbell Law School when it was still in Bowie's Creek. I currently live and practice in Raleigh with my wife and 3 daughters. I'm with Wyrick Robbins, where I lead the firm's appellate practice group. I'm an appellate specialist. I serve on the Appellate Specialization Committee of the State Bar. I serve on the Appellate Rules Committee of the Bar Association. There are about 186 different opinions in all kinds of cases from the Court of Appeals and Supreme Court, both published and unpublished, in which I was either party for counsel for one of the parties or amicus. I'm running because I think that now more than ever we need judges who have the right experience to serve on the North Carolina Court of Appeals. I mean, real hands-on experience handling all the different kinds of cases that court handles. I began my practice at the Court of Appeals clerking for 3 judges. I did practice insurance defense with Patterson Dilthey in Raleigh. I've appealed all the kinds of cases that the North Carolina Court of Appeals hears. I hope you'll agree with me that I do have the right experience. You can find out more about me at tobyhampsonforjudge.com. Thank you very much for the time and the opportunity to address this body. I humbly ask for your support. Thank you very much.